Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this video, we're going to be discussing the aspect of employees in large national and international Canadian companies situated in Canada, and the misperceptions they have with respect to challenging these large companies. So you get terminated, you look at this termination or severance package, and you're not really sure whether or not you should do some analysis, contact a lawyer, and actually pursue the matter any further, or should you simply just sign it, take what they're offering, and be done with it. Because one of the things that people look at and say, this is a big company, they have probably a monstrous company, they have these big law firms at their disposal, tons of money, tons of ability to deal on legal fees. Do I really want to get involved in a fight with this company, given the size and the strength and the legal prowess that you believe that they have? Now, the first thing you should realize is that although they might have a lot of money, and although they can hire what many consider some of the top lawyers, the biggest law firms with extremely large resources, the reality is that what you're dealing with is the back end of a situation. And those lawyers can only deal with what has happened before. They cannot change it. They can try to work it as best as they can, but they are unable to change past circumstances. What has happened, and that is the cards that everyone is dealt with. We don't know what those cards are right now, but in many instances, I do have some perspective as to where the companies have tripped up. And why do they trip up in the lead up to this? Well, they trip up because they are so large, because they are so powerful, and because they expand so much. And because of that, they approach many aspects as a business expansion. They don't coordinate things as a /legal expansion. Some companies may do that, but they only do it on the outskirts of their whole operations. Oftentimes, they do a lot of stuff on the corporate side, on the transactional side, and even on the high-level employment side. What is not happening oftentimes is dealing with matters which they deem or they perceive to be not a legal function, but more an accounting function, a payroll function. And in their growth and in their expansion, they fail to recognize and appreciate the multi-jurisdictional nature of the law. And what do I mean by this? I mean that in every jurisdiction, be it every province or state or nation, there are very distinct aspects to employment law. And these matters are and can be very consequential. And they transpire through the course of one's employment. The law does not only come into play in employment situations at the very beginning of one's employment and at the very end of one's employment. The law operates throughout one's employment and is impacted throughout the process of one's employment. And it is because of that, especially where you're a long-term employee in a company that has grown rapidly, that has expanded rapidly, that has its origins outside your home province or your home country, that you can have the possibility, the very good likelihood, that there are serious issues tied into what has transpired with the company as to employment arrangements with yourself. And this leads to aspects of the law not being followed. So what does this mean? What it means is it provides you legal leverage with which to negotiate those matters related to your employment termination and severance. Because instead of simply saying we're looking at one singular point in time, which is what many lawyers unfortunately do, you are looking at the whole composite of your employment. And you're looking at it from a legal perspective, not from this interactional perspective that the employers might well want to try to focus on. And in turn, you gain considerable leverage in the negotiating field. Naturally, you want to be working with the right professionals, the right legal counsel on this, but this is where you get your strength. Because, as I said before, they might hire the best lawyers to deal with your situation at the end. But there are stuff that potentially, and in all likelihood, unfortunately, has been transacted preceding your termination, which creates serious issues and problems for those employers. And in turn, it positions yourself better. And they cannot shortchange you. They cannot come out and offer you minimalistic arrangements, try to take advantage of loopholes, and disadvantage you. That is absolutely critical to advancing your employment termination and severance package negotiations. You need to have strength in those negotiations. How you find those strengths, how you advance them, how you protect yourself against not getting less than what is offered up. That is why you work with legal counsel that is experienced in these matters. But the fact that you got terminated, fired, dismissed, relieved from a large company that operates in many provinces, many states, many countries, while you're situated in here in Canada, at the end of the day, what you are looking to do is find out, is there an advantage? All employers know and should know, and most of them do suggest that you speak with legal counsel. So what you want to be doing is talking to the right lawyers. Talk to a few lawyers, in fact, if you feel like it. If the first lawyer doesn't come up with any solutions for yourself, talk to another lawyer and see what they are presenting to yourself. See what they're looking at and see where they're identifying your advantages. If there are some. There are cases where there might not be any legitimate advantage. The package might be good, but then it's good to know that. But if it isn't, and you're being shortchanged, and there are tactical positions that you can take to advantage yourself properly, just as your employer has done, or your former employer has done with yourself, why should you not look into it? Why should you not address it? And why should you not get something more appropriate in the way of exit pay, be it termination pay and severance pay and related pays that are due to yourself on your departure from these large companies? So simply don't be afraid to inquire. You have a legal right to inquire about this, and it's not necessarily going to be held against you. They don't even know if you, employers don't really fully know if you simply talk to lawyers. They don't track your phones, we would hope, especially when you're being dismissed. And if you take their package, you've taken their package, but you've got the insight, you've got the confidence that you took the right package. And if you don't, then you take the approach that makes you feel comfortable, that you took the appropriate action to make you feel confident that you did the right thing. And oftentimes that's critical, that you want to know whether or not you're being offered something that was legitimate and right, or if you're going to be underpaid on your exit. Because you got to remember, there is no benefit to the employer once you've been let go. So whether they pay you $50,000 or $80,000 or nothing, they're not getting anything back from that outside the potential of litigation, but they are not getting any beneficial bonus out of that whole process. So given that kind of scenario, what you want to understand is inquire. Contact, speak to knowledgeable legal counsel about the potential that you might have been underpaid. And if you haven't, you haven't. If you have, how do you go about dealing with it? That's the challenge, and that's the opportunity. You've worked long enough for that particular employer. You've put in a lot of time. Why should you not get properly compensated on your exit? And that's all I have to say in this video. And it's up to you to make the determination. Thank you.